Tom, good to see you.
Okay, no. Okay. Good afternoon and thank you. Appreciate you coming out today. I thought it was important to bring you together to remind the public of some of the key facts in the Julius Jones case that I believe are being manipulated to fit a narrative in a orchestrated effort to get Mr. Jones off of death row and perhaps out of prison entirely. And we've heard a lot recently from those who are advocating for his release. I'm here today as an advocate for the late Paul Howell and his family, and I'm here to advocate for the justice that our legal system owes them. They are the victims in this case, make no mistake about it, and the pain of their loss is revisited with each misguided public appeal on Mr. Jones' behalf. There are a lot of facts, and I won't cover all of them for you. Most of them should be in the packet that you've been provided. But let's deal with the first and most important fact. Julius Jones murdered Paul Howell in cold blood in front of his sister and daughters. No celebrity imploration or profusion of misinformation will change that. The information that we're releasing today is from the trial transcript, and it disproves every claim that he is innocent. I strongly encourage those calling for his commutation to read the compelling evidence in this document. Julius Jones had his day in court numerous times. I'll begin with reminding everyone the story around the infamous red bandana. His attorney's complaint was never tested. It was tested in 2018. The conclusive results of the DNA profile show the probability of the DNA belonging to someone other than Jones is 1 in 110 million. Moreover, this bandana was tested for his accomplice, Chris Jordan's DNA. Chris Jordan's DNA was not found on that bandana. During the investigation, officers found the murder weapon wrapped in that red bandana and hidden in the attic space above the ceiling of the closet of Jones' room. And hidden behind the cover of the doorbell chime in his parents' home, officers discovered a loaded .25 caliber magazine belonging to the gun that they found. Both the bullet that killed Mr. Howell and a bullet recovered from Mr. Howell's Suburban were fired by the gun found in the attic. Something else that the public needs to take note of. Subsequent to Mr. Howell's murder, Jones pled guilty to robbery with a firearm and unlawful possession of a firearm. This offense arose out of the armed carjacking of a vehicle outside a hideaway restaurant the week before Howell's murder. The stolen vehicle was recovered from a Norman apartment complex where Jones lived. After Jones and his friend were arrested for Howell's murder, the key to the stolen Mercedes was found in the cutlass shared by Jones and his accomplice. In other brushes with the law, Jones attempted to elude a police officer, was arrested while driving another stolen car in which he had a loaded gun. He robbed a jewelry store at gunpoint, committed another carjacking at the same hideaway during the same week, and fought with a detention officer. Alleged juror bias. The racial bias claim by a juror was thoroughly explored and investigated. previously, during the trial, a juror reported that she heard a provocative comment, not a racial comment, but a provocative comment by a juror. The trial court thoroughly investigated this allegation, interviewed each of the other jurors, none of whom heard the remark. Moreover, the juror indicated that they had only heard part of the remark, and that juror was not even sure that there was a reference made to Julius Jones. And at that time, the reporting juror said nothing to the trial judge to indicate that the juror also used a racial epithet. The Oklahoma Court of Criminal Appeals determined that it is highly improbable that the reporting juror failed to make the current racial bias claim clear to the judge at the time it allegedly happened. Alibi. Jones affirmatively claims that he was at his parents' home at the time Mr. Howell was murdered. A hearing was held on this claim in state court, at which his attorney testified that he discussed the alibi with Jones more than once. And Jones said that he was not at home that evening, that his parents were mistaken. I'll quote from the transcript. Question: Mr. Jones, Julius Jones, denied to you that he was home the evening of the homicide. Answer: sworn testimony. Yes, ma'am. Another of Jones' attorneys, Malcolm Savage, also confirmed that Jones denied being at his parents' home the night of the murder. In addition to Jones' denials, Jones' family claimed another party was with them the night of the murder and could corroborate the alibi. That witness denied that she was at Jones' home on the night of the murder. Megan Tovey's description. Megan Tovey is Paul Howell's sister, who was in the vehicle at the time of the incident. It is widely described that Mr. Howell's sister, who was a witness to the murder, described the gunman as looking more like Jones' accomplice the night of the murder. Advocates for Jones say in her description that she saw braids or cornrows. But, according to the trial transcript, she said she did not see braids or cornrows. She said she could see about a half an inch to an inch of the man's hair between his stocking cap and his ear. These are just a handful of the misleading statements advocates for Julius Jones are perpetuating. As I said, we have more in the handout we provided, and we can get the correct information for anyone who needs it going forward. Julius Jones is guilty. He murdered Paul Howell, and he needs to be held accountable. Mr. Howell's family will never have closure. His two daughters, now grown, had to grow up without their dad. The family was ripped apart by this senseless murder. In my meeting with the family last week, they all described Paul as the golden boy in the family. He was clearly his father's favorite, but none of his brothers or his sister ever took umbrage at that. They also advised that losing Paul also killed Paul's father. He was never the same. So, Julius Jones has been convicted, and no PR campaign can change these facts or refute this evidence. The last thing I will address is last week I sent a letter in response to an inquiry from the Pardon and Parole Board questioning whether or not death row inmates are eligible for commutation. My letter to the board referenced a 2012 Attorney General's opinion that established that the board has constitutional authority to recommend and that the governor has constitutional authority to grant commutations to death row inmates. This office will always follow the law, despite rhetoric to the contrary. Rhetoric last week by Mr. Jones' lawyer who said this office would not follow the law, alleging we would be a biased actor and engage in a flimsy legal cover. Both of those are quotes. I know my responsibilities as Attorney General, and I am faithful to them. It was clear in the 2012 opinion, and it was clear in our review of that opinion, that the Governor and the Pardon and Parole Board have this authority, and that Mr. Jones has a constitutional right to be reviewed for commutation. That's the law. I would ask that Julius Jones advocates, as I try to be, are responsible to the public with respect to their efforts on his behalf. I'll now be happy to take questions.
What led up to your meeting, or what prompted the meeting with the Howell family last week?
The discussion around whether or not the Pardon and Parole Board could entertain commutations for individuals on death row.
Julius has said in his commutation letter, and some of the advocates have said as well, that basically he didn't have a chance to tell his story at the trial because of the lawyers he was given. Do you have anything to say about that, of him saying that he never got a chance to say his story in '99, or when his trial started?
So the issue of whether or not Mr. Jones had competent counsel has been reviewed by appellate courts. That review indicated that their advocacy on his behalf was responsible and consistent with the right to counsel that's afforded individuals under the United States Constitution. Other questions?
Yes, sir. Why do you think the advocates, as you put it, are doing this misleading campaign?
So all I'm asking is for folks to be as responsible as I've demonstrated we're going to be in this office. There was speculation that when we were asked about the constitutional authority of the Pardon and Parole Board and the Governor, that as Mr. Jones' attorney speculated, that we would play games and that we wouldn't be faithful to the rule of law. So all I'm asking is that folks are responsible with their advocacy. There is a good deal of misinformation out there that we're dealing with. I can't count the number of emails I've gotten from folks who've been told certain things that I think are not consistent with the evidence at trial and with the facts. So not trying to question anybody's heart. You know, we've heard from a lot of celebrities. I know that they believe they're doing the right thing based on what they've been told. I'm just not sure that they've been told the right thing consistently. There's a question over here, Ben.
Yeah, a board member, or Pardon and Parole Board member, Alan McCall, had sent a series of emails to the director kind of related to this commutation request. Did you have you read those emails, and if so, did you have a comment on them?
I did read your story.
Okay.
I wouldn't have any comment on them other than the fact that, you know, when we're asked for a legal opinion, we're gonna give the opinion that is required for us to provide based on our oaths of office in this job.
Did Mr. McCall ever reach out to you over the last
No.
several months before that?
No, sir. Anybody else?
This is probably the sort of
Trace.
thing that you did not run for office to do, right? This is probably going to get you some criticism from people coming up here and saying this today. So can you speak to why you felt like you, an elected official, who might run for re-election, this might not be real popular, but you still felt like you needed to come up here and release this information today and reiterate these things you say? Can you speak to that decision?
Well, this is a great job, but it's a tough job. As you know, Trace, I'm not interested in any other jobs. Tried to get this one a long time ago, 1994. There's a reason why attorney generals don't get elected to other things in the state, and it's because you have to make a lot of tough decisions in this job. That's part of the responsibilities. Suffice to say that I was moved by conversations I had with the family last week. They just don't feel like there's anybody advocating on their behalf. They just don't feel like there's anybody reminding people that, they're victims, they continue to deal with this. Paul was a wonderful person who shouldn't have lost his life back on July 28th, 1999. So my answer is I'm just doing my job.
Thank you.
There are also claims from advocates as well that one of Julius's friends basically had him framed for this. Do you have any comment on that as far as people saying that the friend worked with the state basically to frame Julius?
Again, that's been reviewed by appellate courts in depth. Somebody was wearing a red bandana, and that person killed Paul Al. And so there's been some suggestion that it was his accomplice, Mr. Jordan. There's no evidence to support that, particularly after the red bandana was tested and his DNA wasn't found on it, but Julius Jones' DNA was. So I'm sure he's a very different person now than he was back then, and that's important. But there's still a debt to society, and I just want to be clear with everybody that I'm here in an effort to make sure the public has the whole story, not just stuff that's convenient to fit a narrative.
What's the latest status on just executions as of today?
So the execution process is in federal court, Western District, Judge Fryatt. It's being reviewed as to whether or not the court is satisfied that we're going to be able to proceed in a constitutional fashion. So I've made the commitment to the judge that we won't schedule any execution dates with the Department of Corrections until he's finished his review.
Do you imagine scheduling those pretty quickly if the review comes in your favor?
I'm hopeful that we'll complete our federal court matter sometime in the fall. A couple more questions.
And he was wearing the red bandana over his face, is that correct? Because it talks about the stocking cap being black. So is
Stocking
that,
cap and a red bandana.
but where was he wearing the bandana? I'm sorry, I feel like I'm going back in time. here,
Well,
but-
I think similar to how you're wearing your mask there, Trace.
Okay.
Just covering his nose and mouth.
Okay, thank you.
Yeah. One more question. All right, well, listen, thanks for coming out. I appreciate covering today's press conference very much.
Thank you.
Thank you.